Set notification of the parliamentary election results, but opened his phone. He opened his phone in court to say that in open court and to read an online news portal and press conference claiming to have been organized by Dr. Bosman Asari and urged on the court that the results of the Akwatia parliamentary election had been gazetted by the Electoral Commission of Ghana, when same was absolutely untrue. It must be pointed out that on the 5th of January 2025, when counsel for Henry Akwatia was arguing in the court that the parliamentary results for Akwatia constituency had been gazetted, he was in fact misleading the judge, who obviously, because he was also dealing with his whatever technologies you give him, decided not to pay a listening ear to the counsel for the Honorable Ernest Kumi. The judge failed to listen to Ernest Kumi's counsel, and he proceeded to only listen to Honorable Henry Akwatia counsel, who obviously gave him a misleading information. And this is what we captured, that he was in fact misleading the judge because it is public knowledge that the parliamentary results in Akwatia constituency was gazetted on the 6th of January 2025. And same can be found in the Ghana Gazette dated 6th January 2025 at page 8093, with Honorable Ernest Kumi declared as the winner with 19,269 votes, representing 52.83%, and Honorable Akwatia obtaining 17,206 votes, representing 47.17%. Friends of the press, in a ruling delivered by His Lordship Justice Emmanuel Senyo Amedahe on the morning of 6th January 2025, the following is what His Lordship Justice Emmanuel Amedahe stated on the question of jurisdiction to entertain this election petition. And this is captured in pages 6, 3, 4, 5, 6, 7, 8 of the ruling. And I quote, essentially, the applicant through his counsel is saying that the statutory law, that is PMBC Law 284, on which the first respondent herein mounted his substantive action, particularly Section 18 of that Act, expressly provides that an election petition must be brought within 21 days after the publication in the Gazette of the results of the election. It is the case of the applicant herein that the results of the parliamentary election results for the Akwatia constituency in the just ended December 7th election have not been published in the Gazette household. Hence, the action on which the interim injunction was based had not accrued. The applicant is basically challenging the jurisdiction of the court to hear the matter, and rightly so. Counsel for both parties relied on the decision in the Republic versus High Court, Kufuria ex-party Dr. Kofi Asari, Baba Jamal, Mohammed Ahmed, and others, first interested party, and the decision in the case of the Republic versus High Court Judge Sunyani ex-party Alhaji Collins Dauda, who was the applicant then, and Yawati, what in interested party. Citing the decisions of these two cases, counsel for the applicant herein submitted that the course of action, of the respondent had not accrued for him to file an election petition, for which he obtained an interim restraining order from this court. Coincidentally, in that particular issue, it is the argument of counsel for the applicant that the results of the Akwatia constituency has not been gazetted. The jurisdiction of a court to hear a matter is trite, fundamental and non-negotiable in any jurisprudence, especially in Ghana. It is elementary that parliamentary election petitions are primarily cognizable by the High Court as original actions. It is important to note that this distinct jurisdiction of the High Court in election petitions is only properly evoked within 21 days after the publication in the Gazette of the election results. This is stated in Section 18 of the PNDC Law 284 and explained extensively in the ex parte Baba Jamal case, Supra. This was rightly pointed out by counsel for the applicant. But what did the judge do? In the face of all of this, the judge decided to go ahead. Despite the assertion of the applicant that the winner of the Akwatia constituency has not been gazetted, the First Respondents Council states in its submission that the Electoral Commission, in a press conference held in Accra on the 25th of December 2024, announced that it had gazetted parliamentary election results for 274 constituencies. This information can be found on the official website of the Ghana News Agency, the official state news agency, under the heading GC Gazettes 274 parliamentary election results, 2 constituencies outstanding. The publication by Ghana News Agency mentioned the official of the EC who held the conference as Dr. Bosman Asari, a deputy commissioner of the EC in charge of corporate services. At the press conference, the deputy commissioner informed the press that the results of 274 constituencies had been gazetted. Dr. Bosman Asari, in the press release, expressly affirmed that only the election results of Domikwa Benya and Ablikmanot constituencies were outstanding and yet to be gazetted. He also assured Ghanaians that the Commission would finalize the results of these 2 constituencies before swearing in of the 9th Parliament on 7 January 2025. This news item on the website of the Ghana News Agency, which is the state official news agency, cannot be misleading. I have no reason to doubt the Ghana News Agency news item that the 274 elected parliamentarians were gazetted on the 25th of December 2025, which obviously was not the case. Further, this press conference and its subsequent reportage give credence to the fact that election results of Akwatia constituency have been gazetted because Dr. Bosman Asari could have made these assertions after gazetting in line with Regulation 49 of CI 127. Regulations 46 of CI 15 provides as follows. Where any matter is provided in the instrument to be published in the Gazette, it may, in lieu of or in addition to the publication of the Gazette, be published through radio, television, the national newspaper, or any medium of mass communication. From there back, the press held by the Deputy Commissioner on 25th December 2024, where he announced that 274 constituencies had been gazetted by the Commission, is as good as citing the Gazette itself. Ladies and gentlemen of the press, let me first of all state that the Regulation 46 of CI 15, referred to Supra, is a repealed legislation. And let me place emphasis on this, that the law that the judge sought to rely on and the counsel for Akwatia decided to rely on is a repealed legislation. That is, the Regulation 46 of CI 15 referred to Supra is a repealed legislation. The law in force regulating parliamentary and presidential elections in Ghana is the Public Election Regulation 2020 CI 127. In the absence of evidence before the judge, His Lordship Justice Emmanuel Senyo Amedaha, we find it intriguing how he concluded that the press conference organized by Dr. Bosman Asari on the 25th December 2024, where he announced that 274 constituencies had been gazetted by the Electoral Commission, is as good as citing the Gazette itself. This was not grounded. This is because whether election results have been gazetted or not is a matter to be proven by positive evidence and not gleaned from an online publication or news portal. It must be pointed out that Judge Emmanuel Senyo Amedehe agreed with counsel for Honorable Ernest Yakumi that the jurisdiction of the High Court can only be properly invoked within 21 days after the publication in the Gazette of the election results. So, on what basis did he proceed then to hear the matter when the results were not gazetted as at 5th of January 2025? And we need His Lordship the Judge to answer to this. In fact, he had made an order for interim injunction when the court did not have the jurisdiction to make the said order, because he himself agreed with the counsel for Ernest Kumi that the jurisdiction of the High Court can only be properly invoked within 21 days. And that is our matter. That days after the publication in the Gazette of the election results, and page 5 of the ruling dated 6 January 2025 refers. It is only on the back of this ruling, that 6 January 2025, that the learned High Court Judge, Justice Emmanuel Senyo Amedehe, had sought to evict our Honorable Member of Parliament for Akwatia and friend, Ernest Yakumi, for contempt of court. Ladies and gentlemen, the desperation of the judge, of the learned judge, to at all costs convict Honorable Ernest Yakumi is captured in the events after the delivery of this ruling. And let me just share with you a few. On the 8th of January 2025, Ernest Kumi filed an application for certiorari and prohibition at the Supreme Court, seeking to quash the election petition filed at the High Court on December 31st, 2024, along with all related proceedings on grounds of lack of jurisdiction, and to prohibit the presiding judge from further hearing the case before him. Obviously, you know what will happen. The application for certiorari and prohibition was served on the registrar of the court, Mr. Anthony Atachi, on the 24th of January 2025. The affidavits of service show that all the parties, including the judge, who is the respondent in this application for certiorari and prohibition, had been served with the said application. Yet the said judge, His Lordship Justice Senyo Amedehe, did not stop but went ahead or proceeded to hear the case before him. Another application for stay of proceedings was filed at the Supreme Court, and the registrar of the High Court, number 3, Kufridia, was also served with this application. On the 12th of February 2025, but His Lordship Justice Senyo Amedehe, in his usual style, did not stop hearing the case to allow the Supreme Court to determine the merits or otherwise of this application for certiorari and prohibition against him. He went ahead to determine the matter. On the 11th of February 2025, an application to set aside parliamentary election petition filed on the 31st December 2024, and an order for interim injunction, order for substituted service, was granted on the 22nd January 2025, and a motion for committal for contempt filed on the 13th January 2025 for lack of jurisdiction within a return date of 26th February, and that is just a few days away, was filed at the registry of the High Court, number 3, Kufridia, but as usual, Justice Senyo Amedehe decided not to wait to hear the merits of this application before him. The question is, what is the interest of the judge? What is the interest of His Lordship Justice Emmanuel Senyo Amedehe in this case? Is he doing a bidding for somebody at all? Are we not now dealing with proceedings when it has to do with election petition? The judge, His Lordship Justice Senyo Amedehe, once again ignored the processes properly filed before him, and which same were also served on his docket and proceeded to deal with the issue of contempt. On the 24th January 2025, Honorable Ernest Yakumi, given the conduct of the judge, His Lordship Justice Emmanuel Senyo Amedehe filed an application for him to recuse himself on the grounds of bias and prejudice, but he refused to recuse himself. This normally would not happen. The question any reasonable mind would ask is, what is the interest of the judge in the matter before him? That all these applications had been filed at the Supreme Court, including a certiorari, including a stay, and including our application for him to recuse himself. But evidence abound that Justice Senyo Amedehe decided to proceed with alacrity. We are the minority are still worried. At worst, there is a pending application seeking to oust the jurisdiction of the court, including the very contempt application before him on his docket, which is yet to be moved on the 26th of February 2025. It is mind-boggling that while the learned judge did not want to wait to hear the propriety of this application, since this was challenging the foundation of the petition before him, including all the processes and the orders made pursuant to the filing of the parliamentary election petition on 31st December 2024. Ladies and gentlemen of the press, it would interest you to know that on the 18th February 2025, Honorable Ernest Yakumi caused to be filed a motion on notice to arrest the ruling of the judge on the contempt application, but as usual, and in the normal grand style of Justice Senyo Amedehe,
very biased judge,
he decided to show his biasness again. He decided to ignore the application that was pending before the Supreme Court, and for which he had also been handed a copy. In fact, one copy was on his docket. He, in his grand style, decided to go ahead. Interestingly, this is Justice Senyo Amedehe, who at countless moments has thrown the law to the back burner. Interestingly, again, this is the same lawyer who had been attending court and has been filing processes and receiving processes emanating from the registry of the same court. It is doubtful why a court would refuse to hear a lawyer in a contempt matter, because when you even go to the contempt matter, the usual posture of Justice Senyo Amedehe was to ignore the counsel for Honorable Ernest Yakumi. And how is it, can one even phantom this in the criminal jurisprudence? That a lawyer, for someone you are accusing for a certain crime, is there to represent the person, in the person of Ernest Yakumi, and the judge ignored the submissions of the lawyer and proceeded to give a ruling. At this stage, let me state that a contempt matter is a quasi-criminal matter, claiming that the lawyer should have filed an appearance. When somebody came to you earlier, you allowed the person to open the phone to give you details of a certain WhatsApp or a certain publication. But a lawyer comes to stand in for a client in a contempt matter. You are asking the lawyer to file an appearance in a quasi-criminal matter. Hey, Justice Senyo Amedehe. At this stage, let me state further that legal steps have been taken. A notice of appeal has been filed against the ruling of the High Court at the Court of Appeal. An application for stay of execution pending appeal has also been filed at the High Court, number 3, Kuforidia. Moreover, all the parties to the certiorari and prohibition application, including the judge, His Lordship Justice Emmanuel Senyo Amedehe, who is the respondent to this application before the Supreme Court, have been duly served. Further legal steps would be taken, and the minority caucus in Parliament will address the Ghanaian public on the way forward. Ladies and gentlemen of the press, Ghana's democracy thrives on fairness, the rule of law, and the principles of justice. The actions taken against Honorable Ernest Yakumi threaten not only his rights, but also the very foundation of our democratic processes and principles. The judicial system must not be weaponized to serve partisan interest or undermine the will of the people of Akwatia. We call on all well-meaning Ghanaians, civil society organizations, and the relevant authorities to ensure that justice prevails. The law must be applied fairly, and due process must be respected. Any attempt to subvert the democratic will of the people through judicial overreach must be resisted. Ghana's democracy is bigger than any individual or institution. It is our collective duty to safeguard it. Thank you very much, and God bless us all. Thank you.
Leader, a quick one. So there is an active bench warrant on the Akwatia MP. You've enumerated the processes that have been filed. What happens in the interim?
Well,
relative to the bench
nothing
warrant?
happens. They can come in and into the chamber and arrest them. Nothing happens.
Do you intend involving the speaker in this? Because we know he's
Well,
a sitting member of
done.
Parliament.
These are legal strategies we do not want to share. What we want to do is what we have done with you respectfully. So we would expect that whatever steps, when you are dealing with someone who can now be termed a biased judge and you are not too sure of what he stands to do next, you don't share your strategies out. So let's keep our weapons under our little carpet, and then we'll release them as and when. But obviously, from the chronology of events, I have not in my life as a practitioner seen any of this. That where there are major applications emanating from the Supreme Court, you will still see a judge virtually, pardon my language, rubbishing those applications and will proceed to make rulings. And especially when it is an issue of contempt. And a lawyer comes in, and this is also this is the first time I'm hearing that when it is a precise criminal matter, a lawyer has to file an appearance. For the judge to even have made such a remark, this is serious. So I would share with you a copy of the statement, and then I'm sure you can deal with it the way and manner which is positive.
Very, very finally from me, will the people of Akwatia continue to have a representation in Parliament?
He is in Parliament. Hey, Honorable Ernest Yakumi is in Parliament. There is a possibility that he is even going to make a statement on the floor of Parliament today.
Would that not be in defiance of what's happening at the court? Would that not be in defiance of what's happening at the court?
I've just told you, and I'll thank you for allowing me to talk to you. Thank you very much.
Thank you, Leader.